Thanks very much, Preeti. Thanks at the outset. My sincere thanks and gratitude to BCAS and, of course, to you, Preeti, for having me here with all of you to deal with two important topics. Like one is the significant beneficial ownership, and the second one is dematerialization of securities. Significant beneficial ownership was introduced in the year 2018 for the corporates. And in fact, it was when the rules were introduced for the first time, it was actually a nightmarish things for all of us. Fortunately, the Institute of Company Secretaries could get an audience with the Ministry of Corporate Affairs. And I was one of the three members who have been selected to make that representation to MCA. And I was the person who made a presentation to the Joint Director at that point of time, expressing the difficulties in implementation of those rules. And we have given our own suggestions. The MCA was kind enough, and almost 90% of the suggestions what we have given were accepted, and the rules were revised, and the revised rules were notified. And then, to a large extent, we could implement that. In fact, I remember that I might have given about 30 to 35 presentations on significant beneficial ownership across the length and breadth of the country. One of the
And I
reason
was
for
one
that
of the
is,
participants.
oh, okay. One of the reason for that is this particular section, that section 90 of Companies Act 2013, is applicable both to private limited companies as well as to the public companies, listed, unlisted, irrespective of that, it is applicable. And very complex section. And I mean, with all due regards, I still have my own doubts and apprehensions that whether the professionals really are complying with the section the way it is supposed to be complied with. But that, in fact, I always sensitize our professionals of both the institutes, because every one of you might be knowing the regulatory activism which is taking place of late. And especially after MCA version 3, it will be growing more. The reason being the kind of intelligence, artificial intelligence, the kind of other what's called the software tools which have been introduced in that. To the most of the extent, the what's called as the technology itself is going to capture the non-compliances. So one has to be very, very careful not to take any chances. The way registrar of companies are penalizing the companies, directors, KMPs, both CFO as well as company secretaries for trivial issues. And one can never in his wildest dreams also can expect that registrar of companies is going to issue such kind of penal provisions. Say, for example, the minutes books are not serially numbered. They were numbered with pencil, not with the pen. The blank page was not scrolled off. These kind of small trivial issues were taken into account and they have been penalized. So definitely that we all have to be give a very good importance as far as the compliances are concerned and to understand the complex law, especially the significant beneficial owners. So I have a small presentation. Let me make the presentation on both these topics, and after that, at the end of the topics, I will take the question answers also. And I'm sure you're able to see my presentation. Am I correct?
Yeah.
Okay, thanks. So first of all, let me take up this significant beneficial ownership. The objectives of the SBO provisions is to identify the individual who directly or indirectly holds the beneficial interest over the entity. To understand the significant beneficial owner, I can give a simple, on the lighter note, I can give an example that in the good olden days, if you remember, in the movies, there used to be one person wearing a hat and having a cigar in his hand, and he used to be in the dark. Throughout the movie, he used to give instructions to his subordinates. Like in the good olden days, we used to have a Shetty fellow that with a bald head and all. And these people used to implement his instructions. Only at the fag end of the movie, you used to see that person's face. So throughout the entire movie, that person was in dark, and you can only see his hat and some kind of a smoke, but not the face of that person. So it is completely opaque. In the corporates also, same thing happens that to a large extent, some individuals, they are behind the screen, but they operate the levers of the corporates. And their identity is never visible because of the complex web of holdings and cross holding of the companies. Even if somebody wants to catch them also, that one company is holding shares in another company and another company holding shares in another company, like that, it's completely a web. By the time you unwind these kind of relationships also, the cross holdings and holdings, ultimately it is very, very difficult to reach the person who exactly is the person who is pulling the levers. So the ownership entities was completely opaque, and to cover such intricate networks of holdings and cross holding, the provisions of significant beneficial owners have been introduced. Artificial legal entities are often used for illicit purposes, including global crimes such as money laundering, tax evasion, terrorism, and such other activities. So globally also the significant beneficial ownership provisions have been introduced, not only in India. And to the idea is to cover the intricate networks of holdings and cross holdings and to ensure the transparency as well as accountability by identifying and disclosing the identity of such individuals. So, as I mentioned that in the year 2018, the concept of significant beneficial ownership was introduced under the Companies Act 2013 under Section 90. Prior to that, Section 90 was completely rehashed by the new section. Prior to that, the onus was on the government to identify the significant beneficial owner, and they have been given some kind of a powers under this section, whereas post 2017, if I am not wrong, 2017 Amendment Act, this section was completely rehashed and the new provisions have been brought in. This is in addition to the beneficial ownership provisions of Section 89. People normally gets confused that Section 89 is different and Section 90 is different. Section 89 of the Companies Act is for the purpose of beneficial ownership means I am the registered owner, but I am not the beneficial owner. Beneficial owner is someone else. So it is my responsibility to declare that to the company that look, I am the registered owner, but not the beneficial owner. Beneficial owner is Mr. X. And the beneficial owner too has to give a declaration that look, I am the beneficial owner, but not the registered owner. Registered owner is Mr. Y. So company has to, after receiving these two forms, the company has to file with the register of companies. That's how the registrar is coming to know who is the registered owner and who is the beneficial owner. So the onus of filing the declarations was not on the company, but on the registered as well as the beneficial owners. Company was a mere postman. If you file, he will file in turn with the ROC. But company was not under the onus to find out who is the beneficial owner and who is the registered owner. Whereas in case of Section 90, it is not so. It is the responsibility of the individual who is the significant beneficial owner to voluntarily declare that he is the SBO. And it is the responsibility of the company also to identify such person if he has not filed the declaration to get the declaration filed, otherwise to approach the tribunal and to get certain restrictions imposed upon him. Why I'm saying this, though it is today's topic is about LLP SBO rules, because the it is nothing but more or less the same rules have been extended to LLPs also, except that instead of a company, they have used the word LLP, SPO, something like that. That's it. Otherwise, more or less, the summary and substance is the same. What is the rationale for such extension? The rationale is nothing but to align the framework for identification of SPOs of LLPs also to that of companies. And these LLP SPO rules were notified on November 9th, 2023. And as I told you, the provisions are more or less on similar lines to that of the companies under the Companies Act 2013. The difference is mostly in terms of the manner of determining the SPO. In case of LLPs, what they do is the holding of capital contribution is important. As far as the companies are concerned, the shareholding in the companies was there. Voting rights in respect of management or policy decisions of LLPs. In case of companies, it is again shareholding. Right to receive or participate in the distributable profits. In case of companies, it is the dividends. So before going further, we have to understand certain key definitions. One is that control. Control shall include the right to appoint majority of the designated partners or to control the management or policy decisions exercisable by a person, whether directly or indirectly, including by virtue of their contribution or management rights or LLP agreements or any other such agreements. That means when you say that a person who exercises control means that person has a right to appoint majority of the designated partners. That right he acquired, and similarly, he can also control the management or policy decisions. These rights he got because of certain agreement between LLP agreements or because of the his contribution or management rights or any other kind of agreements. Then majority stake. Majority stake means holding more than one half of the equity share capital in the body corporate. Because why we have to understand the majority stake is if a body corporate is a partner in the LLP, when you identify the SBO, it is the individual who is holding majority stake in the body corporate. So you need to understand the definition of majority stake. So holding more than one half of the equity share capital in the body corporate or holding more than one half of the contribution if it is a partnership is the entity, more than one half of the voting rights in the body corporate, or having a right to receive or participate in more than one half of the distributable dividend or distributable profits or any other distribution by the body corporate, including a partnership entity, as the case may be. Because when we are identifying in case of a limited liability partnership, the partners of the LLP, not necessarily to be the individuals, the partners of LLP may be body corporates, they may be also LLPs further or partnership entities. So, how to identify the in such case? The body corporate cannot be the significant beneficial owner. The partnership entity cannot be the significant beneficial owner. So, it is the individual who holds the majority stake. He is going to be the SBO. Now, partnership entity is also defined under the rules. It means that a registered firm under the Indian Partnership Act 1932 or a limited liability partnership registered under the LLP Act. Very surprisingly, unregistered firms are not covered under this. In fact, when the SBO rules for the Companies Act was getting framed, that point of time, we brought this to the notice of MCA. Why can't you clarify this? Because unregistered firms are not coming. Is that the intention? Somehow, I don't know what is the reason for that, but they never addressed that issue. So, as on date, we can safely say that if an unregistered partnership firm, through its partners, is a member of the LLP, they are not to be considered as far as SBO is concerned. Same is the case with case of Companies Act also. Reporting limited liability partnership means this SBO rules are applicable to all the LLPs and any LLP which has to identify the SBO, which has to ensure the compliances, that LLP is referred to as reporting limited liability partnership in the rules. Now, the main definition, significant beneficial owner. Who is the significant beneficial owner? In relation to a reporting LLP means an individual who acting alone or together or through one or more persons or trust possesses one or more of the following rights or entitlements in such reporting limited liability partnership. Means what? The significant beneficial owner means an individual. So always the SBO should be an individual. It cannot be a body corporate. It cannot be an LLP. It cannot be a trust. It cannot be a HUF. So individual, he is the person who is to be identified, whose identity is camouflaged or whose identity is opaque, and he is to be brought into the picture. So that individual who acting on his own or together with some other entities and having one or more of the following rights or entitlements. What are those? He holds indirectly or together with any direct holding not less than 10% of the contribution. When that individual will be identified as an SBO is when he holds indirectly or together with any direct holding not less than 10% of the contribution in the LLP. Holds indirectly or together with any direct holdings not less than 10% of the voting rights in respect of the management or policy decisions of such LLP. He has a right to receive or participate in not less than 10% of the total distributable profits or any other distribution in a financial year through indirect holdings alone or together with any direct holdings. Has a right to exercise or actually exercises significant influence or control in any manner other than through direct holdings alone. So if you see that wherever I have put it in the red color, holds indirectly or together, holds indirectly or together with any direct holdings. That means to get identified as a significant beneficial owner, an individual has to necessarily hold some indirect holding. If he is simply having a direct holding in his own name, he is not a SBO at all. Why? Because there is no opaqueness. He has registered all the shares in his own name. So we know his identity. When you know his identity, why he has to declare himself as the significant beneficial owner? Because in the register of members or in the register of LLPs, his name is there already. So he has to necessarily hold indirect holding, maybe together with his direct holding. That indirect holding itself may be more than 10% of the contribution, or indirect holding together with his direct holdings may be more than 10% of the contribution, or 10% of the voting rights, or 10% of the distributable profits, and then he exercises significant influence or control. That's why we have seen the words, the definitions of these two, in any other manner than through direct holdings alone. That means even exercising the significant influence also will be through indirect holdings. So what is acting together? Because when he is exercising significant influence or control, he need not act alone. He may be acting together with others. So acting together, the definition is there. For the purposes of this class, if any individual or individuals acting through any person or trust act with a common intent or purpose, exercising control or significant influence over the reporting limited liability partnership, may be pursuant to an agreement or an understanding. It may be formal or it may be informal. Such individuals or individuals acting through any person or trust, as the case may be, shall be deemed to be acting together. Means these people, if they are acting together, to to tell that they're acting together, they have to have a common intent or purpose, are exercising control or significant influence over that reporting LLP with an understanding which may be formal or informal. Such individuals are also known as significant beneficial owners. So, what is a significant influence? Significant influence means the power to participate directly or indirectly in the financial or operating decisions, but is not control or joint control of those policies. Now, if you see that rules, there are 4, 5 explanations are there. The first explanation talks about for the purposes of this clause, that means for the purposes of the significant beneficial owner identification. If an individual doesn't hold any right or entitlement indirectly, he shall not be considered to be a significant beneficial owner. That means if an individual holding more than 10% of the the contribution, etc., etc., through indirect holding, then only he will be an SBO. Suppose if an individual holding say 60%, 70%, 80% of the contribution, still he is not an SBO because, as I mentioned to you, there is no opaqueness, there is no identity crisis, there is no what's called as an okay that the person is not behind the show because he himself has I mean, his whatever the contribution is there and all, it is registered in his name directly. So when an individual is not having any indirect holding, he is not a significant beneficial owner. However, suppose, for example, he got 80% of holding even a single rupee contribution, if he is having through indirectly, that means suppose he is having a what's called as an okay a body corporate. That body corporate is holding 1% of the LLP contribution or 1% of LLP voting right. And this person is holding majority stake in that body corporate. And if together with that indirect holding of 1% and with his direct holding of say 80%, 70%, whatever it is, since it is exceeding 10%, he becomes a significant beneficial owner. That means directly you may be having any amount, no problem. But indirectly you are having something together with your direct holding, even a single rupee indirect contribution, you have to become, you will become a significant beneficial owner. Explanation 2 talks about an individual shall be considered to hold a right or entitlement directly in the reporting LLP if he satisfies any of the following criteria. So explanation 2 also talks about direct holding. In this case, what is happening is that holding is not registered in his name. So the contribution in the reporting LLP representing such right or entitlement are held in the name of the individual. That means another individual. And the individual holds or acquires a beneficial interest in the contribution of the reporting LLP. So has made a declaration in this regard to the reporting LLP. That means what? As I told you in case of section 89, if a person might be a registered owner, the beneficial owner is somebody else. So in case of LLPs also it may happen the same thing. The partner whose name is registered, who has entered into that agreement, he might be a registered owner, but beneficial owner is somebody else. But his beneficial ownership has been declared under Rule 22P of the LLP Rules 2009. In such case, his identity again is already revealed, so there is no question of any kind of SBO. Explanation 3 talks about when a partner is a body corporate. Now the question comes, let us say one by one. In the LLP, there may be individuals, there may not be individuals, there may be, suppose two body corporates can also form an LLP or three body corporates may form an LLP. Now the question comes, who is the SPO? Say for example, there are three body corporates who are the partners of an LLP. And one body corporate, I mean, okay, that ultimately when we have to find out which body corporate, everywhere you have to go one by one, A, B, C, and there are three body corporates are there. So you have to see that in case of A, who is the individual holding majority stake in that body corporate. That may say, for example, it is a company. A company is suppose a registered company in India is known as company and a company registered outside India is known as body corporate. So let us say that in one company is holding, he is a partner in the LLP, and who is the individual holding majority stake in that company, he will become the SBO. Majority stake is what? 50% plus shareholding, 50% plus voting right, 50% plus to receive the dividends, etc. Or that is what the majority stake is concerned. So in this case also, if the body corporate is a partner in the LLP, you have to say that who is the individual holding majority stake in that body corporate, he will become the significant beneficial owner of that LLP. The second thing comes that in case of a partnership, is it necessary that only one person becomes a partner? I mean, that a significant beneficial owner in the profit sharing ratio. Say, for example, there are three partners are there, as I told you, A, B, C, all the three are body corporates. A is contributed 90%, B contributed 5%, C contributed, say, another 5%. In case of A, who has contributed 90%, there is no individual holding majority stake at all. Who is the SBO there? There is no SBO there. In case of B, who is contributed, say, for example, 5%, in his case, also there is no individual holding majority stake. That means no individual is holding 50% plus. So there also no SBO. But in the third case, there is an individual who is holding majority. In that case, he will become the SBO. So where the partner of the reporting LLP is a body corporate, whether incorporated or registered in India or abroad, other than a limited liability partnership, and individual holding majority stake in that partner or holds majority stake in the ultimate holding company, whether incorporated or registered in India or abroad of that partner. That means what? If in case of a body corporate is a partner in an LLP and that body corporate is holding more than 10% contribution or voting right or distributable profits, to identify the individual who is holding the majority stake of that body corporate. Suppose sometimes it may so happen he is not there is no individual holding majority stake in the body corporate, but you have to see also that any individual holding majority stake in the ultimate holding company. Because what happens sometimes, the there may be what's called as four layers of subsidiaries. A is the holding company, B is subsidiary, C is another subsidiary, D is another subsidiary. Like that, there may be a series of subsidiaries are there. And that suppose F, which is a subsidiary, is a partner in the LLP, and F is not having any individual holding majority stake. That means you cannot conclude there is no SBO. You have to also see the ultimate holding company, that is A. So A, if any individual is holding a majority stake there, he will become the SBO. This is how the SBO is to be worked out as far as the partnership is concerned. Let me also say that it is not necessary that every LLP will have or every company will have a significant beneficial owner. It is not necessary that a SBO is there. If the SBO is not there, a simple declaration is to be required. A person who is having more than 10% contribution, that body corporate has to give a declaration stating that, look, in my in me, there is no individual holding a majority stake. Hence, there is no significant beneficial owner. That declaration is to be taken on record and keep it. Now, if the partner is a HUF, then what happens? You have to see that if the partner is HUF, and obviously the partner can be if the HUF is a partner, it can be through its Karta. So, in case that Karta is holding a majority stake, then he will become the SBO. If the Karta is not holding majority stake, then he will not become, there is no SBO at all. The partner is a partnership entity. As I told you that where the partner of the reporting LLP is a partnership entity. It might not be LLP, but it is a registered partnership. And that registered partnership is a partner of the LLP. And the individual who is a partner or holds majority stake in the body corporate, which is a partner, or the partnership entity, or holds majority stake in the ultimate holding company of the body corporate, which is a partner of the partnership entity. So in the above case, all the partners, that means where a registered partnership is a partner of the LLP, then you have to see that who is the individual, who is a partner of that registered partnership firm, holds majority stake in the body corporate. Suppose again, if a body corporate is in that partnership, another body corporate is a partner. Again, the same logic you have to apply. Who is the person holding majority stake? And in this case, what happens is that all the partners, irrespective of the sharing of the ratio, all the partners become the significant beneficial owners. Suppose somebody might be holding, say, 50% partner in profit sharing ratio, and somebody is 25%, another person is 25%. So it is not proportionate. It is all the partners will become the SBOs. Now, the LLP is having a partner who is a trust, which is a trust. A trust can be a partner in an LLP through the trustees. Then, in such case, who will become the significant beneficial owner? The SBO will be a trustee in case it is a discretionary trust or a charitable trust. The SBO will be a beneficiary in case of a specific trust. SBO is the author or settler in case of a revocable trust. Why it is? Because in case of discretionary trust or a charitable trust, who will get how much percentage of the benefit out of the trust, it determines by the trustee. So it is the trustee who exercises control or significant influence of that trust. So he is the person who is responsible. In case of a specific trust, what happens is that the beneficiary's beneficial holding is already predetermined. Because of that, here it is not the trustee, it is the beneficiary who will be the significant beneficial owner. And in case of a revocable trust, that means that trust can be revoked at any point of time. In such case, neither the trustee nor the beneficiary, but the author of the trust or the settlor of the trust, he will become the SBO. In case of a pooled investment vehicle, who will again a pooled investment vehicle, suppose if it is a partner of the LLP, in such case, the entity controlled by the pooled investment vehicle will, if it is based on the member state of the Financial Action Task Force on money laundering and the regulator of the securities market in such member state is a member of the International Organization of Security Commissions. In such case, the pooled investment vehicle is a general partner or is an investment manager. Whoever is there, he will be the SBO. The general partner may be the SBO or the CEO of that, where the investment manager of such pooled investment vehicle is a body corporate, the CEO of such body corporate will be the SPO. Suppose where the partner of a reporting LLP is a pooled investment vehicle and that entity is controlled by the pooled investment vehicle, such investment vehicle is based on the jurisdiction which does not fulfill the requirements referred to in clause 5, that means the above clause which I have mentioned to you, the provisions of clause 1, 2, or 3, or 4, then this case may be applied. Now, let us see what are the compliances we have to do. Once you are identified the significant beneficial owner, or suppose you are that significant beneficial owner has not voluntarily came front to declare himself as an SBO, what you have to do it. So every reporting LLP shall take necessary steps to find out whether there is an individual who is a significant beneficial owner and cause such individual to make the declaration in the form LLP Ben 1. That means what? Based on the information available with the LLP must be knowing who are all the partners having more than 10% plus contribution, who are the partners entitled for 10% plus voting rights, 10% plus distributable profits. In such case, those partners, if they are whatever it is, if they are individuals or body corporates or HUFs or trust or pooled investment vehicles, which we have discussed. So ultimately, that individuals who are there, they have to file a declaration in LLP Pen 1 that so and so is the SBO. Alternately, what they have to do, they have to file a declaration that in if it is not an individual, if it is a what's called a body corporate, etc., etc., they have to say that no individual is holding a majority stake in me. Because of that, there is no significant beneficial owner. That declaration should be in writing with proper authentication. The person who is giving that kind of an information, he should have been authorized by the concerned body corporate or ever HOF or partnership form, whatever it is. So, without prejudice to sub-rule 1, every reporting LLP shall, in cases where the partner holds not less than 10% of its contribution, voting rights, right to receive or participate in distributable profits. That means if that person is not, that partnership entity is not voluntarily filing that LLP Ben 1, then the reporting LLP, it has to give a notice, show cause notice to all those people who are holding 10% plus in that LLP that look, as per our records, you are supposed to file the significant beneficial owner. Please identify who is the individual, who is the significant beneficial owner, and please file the LLP Ben 1 with us. And every individual who is a SPO in the reporting LLP shall file a declaration, as I told you, in LLP Ben 1 to the reporting LLP within 90 days from the commencement of these rules. So every individual who subsequently becomes an SPO, so not at the time of at the commencement of the rules, if you are already an SBO, you have to file LLP Pen 1. Sometimes it may so happen you have acquired the shareholding or a contribution or voting rights, etc., etc. Then within 30 days of you becoming the SBO, you have to file that LLP Pen 1, where an individual becomes SBO or where his significant beneficial ownership undergoes any change within 90 days of commencement of these rules, it shall be deemed that such individual became the significant beneficial owner or any change therein happened on the date of expiry of 90 days from the commencement, and the period of 30 days for filing will be reckoned accordingly. Means what? Within 90 days, when the rules were commenced, when the rules were notified and came into force, if a person is an SPO already, within 90 days, he has to file LLP Ben 1. Suppose within these 90 days itself, again there is a change in that SBO, that change is also to be filed within 30 days of that particular change. That means what? For example, Mr. A has been identified as significant beneficial owner as on the date when the rules were commenced. Say, for example, after 45 days or 60 days, that there is a change because he has disposed of his holding or he has disposed of his contribution to somebody else, and that somebody else he has become falling in the definition of SBO, then you have to file number one LLP Ben 1 for Mr. A, who was the SBO on the date when the rules were notified, and another LLP Ben 1 for the change of the SBO within 30 days of that. Now, another tricky issue here is they say that any change in happened in the significant beneficial owner that is to be filed. This particular point we have brought to the notice of MCA. Any change means what? Even one share in case of a company, or here also, suppose even 1 rupee contribution, there is a change, it amounts to a change because the change is not defined anywhere. So one has to be very careful. They have to take a call. That clarity is not there. So when any kind of any change happens, maybe a 1% or half a percent, depending upon the stakes involved in that, that SBO changes to be happened. In fact, say for example, in fact, when we were apprising MC at that point of time, we said that once a person has been declared SBO, say I am having, say for example, 50%, suppose okay, I am a majority stakeholder and my body corporate is holding more than 10% in the LLP. That 10%, if it becomes 20%, 30%, 40%, how does it matter? Because already the identity is revealed. If that 10% becomes, say, 8%, then I am no more a significant beneficial owner. That change is to be informed, but not otherwise. But unfortunately, this particular what's called a dilemma is there, and companies are taking their own call because despite that MCA is yet to be clarified what does it mean by a change in the SBO. Now, once LLP Ben 1 is filed with the reporting LLP, the reporting LLP shall file LLP Ben 2 with the registrar within a period of 30 days from the date of receipt of such a declaration. Say, for example, if the LLP Ben 1 is not received, but the LLP reporting LLP has received a declaration from the partner that there is no SBO, then the reporting LLP need not file a LLP Ben 2. The limited liability partnership, that means the reporting LLP, it shall maintain a register of significant beneficial owners in form LLP Ben 3, and this register shall be open for inspection. In case a the reporting LLP shall give notice in Ben 4, as I told you, a show cause notice is to be given to the SBO, that means to the partners who are holding more than 10% contribution, voting right, or distributable profits. If they have not voluntarily filed, you have to give a show cause notice, and that show cause notice is to be given in the LLP Ben 4. Suppose after that, the SBO or the partner has not replied, then the reporting LLP, what it has to do, as I mentioned to you earlier, they have to appeal to NCLT and stating that where any person fails to give the information required by the notice in LLP Ben 4, within the time specified. That means you have given a show cause notice that as per our records, you are holding more than 10%. Please inform the who is the SBO. They have not responded. Please appeal to NCLT. Or suppose they have given some information, but you that information is not satisfactory. They have given some goalmole reply they दिया उन्होंने. Then you are not happy with that. In such case, also you have to make an appeal to the NCLT. And what is that appeal going to be? It is for an order directing that the contribution in question be subject to such restrictions. That means the partner's contribution, NCLT has to put some restrictions with regard to the transfer of interest attached to that contribution in question, or suspension of the right to receive profits, or any other distribution in relation to that contribution, or suspension of voting rights in relation to the contribution in question, or any other restriction on all or any of the rights attached with the contribution in question. That means what? If that significant beneficial owner, if he is really there, he cannot remain opaque. He has to come to the foreclosure. And if not, then the reporting LLP has to go to the tribunal, make an appeal, get the restrictions imposed. So that person has to come to you and he has to give information either way. That means he has to say that, look, so and so is the SBO, or you have to give a declaration with some kind of documentary evidence that in their case, there is no individual holding majority stake, so there is no significant beneficial owner. So these rules are not applicable to the reporting LLP if the contribution in the reporting LLP is held by the central government, state government, or any local authority. That means if the partner of the reporting LLP is a central government or a state government or any local authority, SBO rules are not applicable to them. So central government, state governments need not inform that who is the SBO. In fact, when the original rules came, this clarification was not there. We asked at that point of time, who, in case of a central government, if these rules are applicable, means what? It is the president of India. He is going to be the SBO. Can we say that? In case of state government, the governor of the state, he is going to be the SBO. But fortunately, subsequently, what they did in case of Companies Act, they have given these exemptions. The same exemptions have been extended in case of reporting LLPs also. A reporting LLP or body corporate or an entity controlled by the central government or by one or more state governments, this is not applicable. That means they may not be holding contribution, but they are controlling that reporting LLP. In such case also, because it is a government involvement, these rules are not applicable. In case of an investment vehicle, that is, I told you that pooled investment vehicle, if it is registered and regulated by SEBI, such as mutual funds, alternative investment funds, real estate investment trusts, or InvITs, if they are the partners in that partnership reporting LLP, they for to them the SBO rules are not applicable. Similarly, if the investment vehicles are regulated by the Reserve Bank of India, IRDA, pension funds regulated, there is PFRDA. So if that investment vehicle is regulated by these kind of regulators, and those investment vehicles are partners in the LLP reporting LLP, then the SBO rules are not applicable to them also. So to summarize and to understand that, what are the obligations of the reporting? What are the obligations of the SBO, who is the individual? Number one, you have to come with a declaration that whoever is the individual falling under the definition of an SBO, he has to file LLP Ben 1 with the reporting LLP within 90 days of November 9, 2023. That is the date when the SBO rules were notified. Within 90 days means February 7, 2024. Thereafter, that is the initial disclosure. Thereafter, continual disclosure. That means as and when there is a change in the SBO, that change is to be filed within 30 days by way of, again, LLP Ben 1. Changes in the SBO during the transition period, I already mentioned that. Suppose on the date of the notification, if a person is an SBO and there is a change in the SBO holding, that initial LLP Ben 1 Subsequently, for the change LLP Ben 1, within 30 days are also to be filed. What are the obligations of the reporting LLP? Every reporting LLP will be required to take the necessary steps to find out if there is an individual who is the SBO and he has not filed the LLP Ben 1. Suppose if the individual who is the SBO, if he files the LLP Ben 1, the reporting LLP has to file LLP Ben 2 with the ROC. Suppose if he has not filed the LLP Ben 1, then the reporting LLP has to give a show cause notice in LLP Ben 4 to that particular partners who are on there. And I told you, if you have not received a reply or if the reply is not to your satisfaction, that reporting LLP has to approach the NCLT for getting the restrictions imposed upon. So this is as far as the SBO rules are concerned. Slightly complicated. One need to give a thorough reading to understand that how to identify the significant beneficial owner. A very, though it is a complicated and complex section as well as the rules, but one has to understand and ensure the proper implementation of that. As I told you that the purpose of identifying the significant beneficial owner is nothing but the person who is camouflaging his identity, pulling the levers, sitting behind the show, his identity is to be revealed so that the kind of nonsense, whatever was happening under the garb of the corporates or LLPs, that should come out. That is the main objective of significant beneficial ownership rules. Now let us see the dematerialization of securities. This was also recently it has been extended to even private limited companies. I used to always say to the company secretaries, especially at one point of time, the company secretaries who were working for private limited companies, they used to have a kind of inferiority complex because the amount of compliances for private limited companies were not many. So, what always people used to say, even the management used to think that they are a burden because sometimes, because of the erstwhile Section 383A, and now because of your Section 204, 203, and the rules, Rule 8 or whatever it is, you have to have a company secretary. So they used to think this fellow is a burden, compliance is a burden. But somehow now what happens is, whether it is a private company or whether it is a public company, listed company, unlisted company, it doesn't matter. Companies Act 2013 has completely changed the rules of the game, and majority of the provisions are applicable to private limited companies also, except the privileges what were enjoyed under the Companies Act 1956 by private limited companies. Those privileges are now available to small companies. What are the small companies? There is a definition is there in the Companies Act based on their capital or turnover. Small companies are defined, and for them, the compliances are slightly less. Otherwise, to a large extent, private public discrimination has been removed. Till recently, of course, the private limited companies were not required to dematerialize the securities, but now they too have to dematerialize the securities. Now, let us see these provisions, how they have been, what's called, enforced. So before that, let me also give you a prehistory of that because you have to also understand where it started and how it has been traveled and now where we are reaching it. In Companies Act 2013, there is one section 29. According to this section, public offer of securities shall be in dematerialized form only. Prior to that, when the public offer was there, you could have, I mean, several of us were knowing that, but the moment you make an application, you want to get your share certificates. After the share certificates come to you, then only you can sell it in the market. Whereas now what they say is any company, post Companies Act 2013, if they have to offer securities to the public, they can offer only in demat form. So according to this section, the following companies shall issue securities only in demat form. That is, every company making the public offer. Obviously, before making the public offer, that company has to be a public company. It cannot be a private company because one of the major restrictions on a private company is you cannot issue the shares to the public. So every company making offer to the public on and such other class or classes of public companies as may be prescribed. Please read that word public companies, which I have put in red color. That means the government's power were restricted. Only this what's called a requirement can be extended public companies. That means every company making public offer or to such other classes of public companies. So you cannot extend this requirement to the private companies. So in now then what happened was by Companies Amendment Act 2019, the word public from subsection 1B was omitted because government was hell bent to again to bring everything to the surface, every financial transaction to the surface. That is one of the requirement. And as we know that these days, the digital payments mode, which is rampant these days, every transaction of ours is being coming into the surface. As we know that GPay, your pay phone, this pay, that pay, Paytm, PTM, all these transactions, even your washerman, your presswala, your vegetable fellows, and nobody is handling cash these days. Everybody wants the GPay only. With this, what happens is that the economy is getting improved. That is what the one of the objectives of this digital payment. Of course, it has come very handy during the COVID period, and it was very successful. More or less, in objective of bringing the dematerialization of securities also is the same thing because people were putting that black money into the investments, having the share certificates, which were not coming into the surface. So now what happens is that everything you have to have in the digital form. So by the Companies Amendment Act 2019, what was done, the word public has been removed. With this, it has to be read as such other class or classes of companies as may be prescribed. That means they can also extend this requirement to private companies also. So the placement has been made with the Companies Amendment Act 2019. Another 4 years by the time the same was enforced now. So in addition to the above, also a provision has been inserted in Section 29, subsection 1, stating that provided that in such class or classes of unlisted companies, as may be prescribed, the securities shall be held or transferred, not only holding, even transfer of the securities shall be only in the dematerialized form in the manner laid down in the Depositories Act 1996 and the regulations made thereunder for such dematerialization. This means such companies, a holder cannot go for rematting the securities because they are saying that the securities shall be held or transferred. Shall be held means once you got dematerialized, you cannot go for rematerialization. And even the transfer also, it should be in the dematerialized form only. Now let us rule 9, if you see that holding of the securities in demat mode, the PAS rules that is called as companies prospectus and allotment security rules, rule 9 of these rules deals with the dematerialization of securities. This rule 9 prescribes that the promoters of a public company, before making a public offer of any convertible securities, shall hold such securities only in demat form. That means whenever a company is coming with a public offer, the first and foremost thing is the promoters of such company, they shall hold the securities only in demat form. Only post that they can bring the public offer and not before that. Anyway, the public offer, when you are bringing the securities, what you are going to allot to the public, they will be in demat mode only. So before that, even the promoters mandatorily, compulsorily, they have to transfer the entire their holding into demat form. The entire holding of convertible securities, whether it is securities or even a convertible security into equity shares, till the date of the IPO shall be converted into demat form before such offer is made. After the IPO, the promoter shall hold the securities in demat form only. Because of that, they can't remat those shares. Now, another rule 9A has been introduced. This was this rule 9A was effective from 2nd of October 2018. Under this rule, that every unlisted public company shall issue the securities only in Demat form. That means what? Prior to Rule 9A, in the Rule 9, only the promoters were to hold the shares in Demat form, and the new offer to the public should be in Demat form. Now, by the introduction of Rule 9A in the year 2018, they said that every unlisted public company, they also shall issue the securities only in Demat form. That means no securities can be issued, whether it is equity shares or preference shares or debentures, bonds, whatever you may call it as. Securities wide definition is there. Those issue of securities shall be only in Demat form. And it is the responsibility of the company to dematerialize all the existing securities. That means, suppose if a company is having, say, 50 shareholders, the company has to facilitate the dematerialization of all that, the holdings of that 50 shareholders. Facilitation means what? The company has to approach a depository with an application and pay the fees, and it has to get its securities admitted in that depository. They have to get a ISIN number. That means with that number, your company's securities will be identified. That ISIN number is to be intimated to the shareholders. With that number, the shareholders have to approach the company or the R&T agent with the request that their shares are to be dematerialized. Not only at the time of issue of further securities, every unlisted public company, before the issue or buyback of any securities, entire holding of the promoters, directors, KMPs shall be in demat mode. That means before issuing any securities or before announcing any buyback of securities by an unlisted public company, the entire holding of promoters, directors, KMPs also shall be in demat mode. So every holder of the securities who intends to transfer shall get the securities dematerialized before such transfer. Because if you see in point number one and point number two, what they were talking about in point number one is only future issue of securities. They have not asked you that normal shareholders to demat those shareholdings. Only in point number two, they asked whom? They say that before the issue or before a buyback of securities, only the promoters, directors, KMPs have to mandatorily convert the securities. Here also, they are not asked the shareholder who are the existing shareholders who are holding shares in physical mode. They have to mandatorily convert into demat mode. They have not asked for that. But what they put one condition was, if those shareholders wants to or they intends to transfer the securities to somebody else, then in such case, the transfer can be effected by the company only when the shares are in demat mode. That means what? Till the time you want to continue in physical mode, you continue it. But when you want to transfer, you have to have those securities dematerialized. So every holder who intends to, then another way of to bring the existing shareholder, they brought one more thing also apart from the transfer. If the holder, that means the existing shareholders, if they intend to subscribe to any securities of the unlisted public company, if that public company are issuing securities by way of private placement or a rights issue or a bonus issue, that company shall ensure that all its existing securities are held in demat mode before such subscription. That means, as I told you, that a company can issue securities only in demat mode. If the existing shareholders, if they want to participate in such issue of the shares by the company, they have to ensure that their entire holding shall be dematerialized. Then only they can get the bonus shares. Then only they can get the right shares. Then only they can participate in the private placement. Otherwise, they can't do it. So while offering securities in buyback, it is not necessary for the holders other than the promoters, directors, KMPs. If you see in the previous slide as well as this slide, in case of a buyback, only the promoters, directors, or KMPs have been asked to convert their securities in demat mode, but not the existing shareholders, because existing shareholders have to mandatorily dematerialize the securities only if they want to participate in the private placement, rights, or bonus issues. In case of buyback, what will happen? they have to surrender the certificates anyway to the company, and those certificates are to be extinguished. That's why whether they hold in demat mode or not, it doesn't matter. Now, this Second Amendment rules which have come now, that passed Second Amendment rules 2023. So far, what we discussed when the company was coming for with the public issue for the first time. Second thing is that unlisted public companies, effective 2018, they all have to convert the physical certificates into dematerialized form. Now, from October 27, 2023, these rules have been further rules have been the Second Amendment rules of prospectus. I mean prospectus and subscription rules have been changed. And here, what they did was a timeline of 18 months is provided from the closure of the financial year, in which a private company, which is not a small company, for the compliance with the mandatory dematerialization requirements. That means October 27, 2023, the rules were notified, and a good amount of time has been given for the private limited companies to, which is, if they are small company, then these rules are not applicable to them. They can continue to handle those shares in physical mode only. But if that private company is not a small company, then if that private company is not a small company, on the closure of the finance, on the date of the closure of the financial year, then within 18 months of the rules notified, they have to mandatorily dematerialize those securities. Now, every public company which has issued share warrants, of course, this is not private company, but the amendment also brought these rules about the issue of share warrants. So every public company which has issued share warrants prior to the commencement of Companies Act 2013 and not converted into shares, because some people what they did was the moment the Companies Act 2013 has come, the issue of fresh shares were to be in the demat mode. So some people what they did, despite the fact they were having the share warrants with them, because there is no limit for the share warrants to get exercised, so they are not come forward. So such share warrants, if anything, are not converted into shares within a period of 3 months of the commencement of these rules. Such companies have to inform the registrar about the details of such share warrants which are still in physical mode. Then, within a period of 6 months of the commencement of these rules, such companies have to, the bearers of the share warrants have to surrender such warrants to the company and get the shares dematerialized. That means now a upper ceiling has been given. Within 3 months, you have to identify the people and intimate the ROC. And within a period of 6 months, the bearers of the share warrants, they have to approach the company for conversion. And before that, they have to get their holdings into dematerialized also. Company shall place a notice for the bearers of the share warrants. For their notice, they have to put in pass 8 on the website of the company. You have to put that these are all the people who are holding the share warrants wherein they are entitled to get the securities of the company. And they have to also publish such information in the newspapers. In case, despite that, if the bearers of the share warrants are not coming forward within the period given, that means 6 months, the company shall convert the such share warrants into securities in a dematerialized mode, transfer those securities to IEPF account. As we know that in case if anybody is not encashing the dividend for a period of 7 years, not only the dividend amount, even the shares are also to be transferred to IEPF account. Same is the case here also. If the bearers of the share warrants are not coming forward, convert their warrants into securities and getting the shares dematerialized, then the company have to dematerialize, they have to issue the shares, dematerialize those shares, transfer it to IEPF account. Subsequently, if any bearer of those share warrants, if he wants to reclaim those from IEPF authority, he can always claim that. Now, these private companies, whenever they want to issue securities, they have to issue only in the demat form. That means exactly just like a public company at the time of IPO, or unlisted public companies when they want to issue right shares or bonus shares or private placement. Even the private companies, which are not small companies, they have to issue securities only in demat mode, and they have to facilitate the dematerialization of all its securities. That may, as I told you, they have to approach the depository, get the ISIN, intimate all the shareholders so that they can convert their shares into demat mode. So a private company which, as on the last date of the financial year, ending on or after 31st March 23, if it is not a small company, as per the audited financial statements, for such financial year, within 18 months of the closure of the financial year, comply with this provisions of the rule. A full 18 months time has been given for them to do this. So let us also understand, because we are talking about the small company, I thought let me put a slide so that you can understand what is a small company as per section 2, subsection 85. A small company means a company, a public company, sorry, a company other than a public company having a paid up capital of not exceeding 50 lakh rupees, and a company whose turnover as per the P&L account for the immediately preceding financial year doesn't exceed rupees 2 crores, that company is defined as a small company. So timeline for the compliances, as I told you, that in case a company ceases to be a small company after 31st March 2023, the timeline of 18 months triggers from the closure of the financial year in which it ceases to be a small company. Suppose if a company is not a small company, as per the financial statement, as on 31st March 2023, the shareholders have to dematerialize their shares within 18 months, that is September 30th, 2024. If a company ceases to be a small company at any time during the financial year 23-24, it is by as on 31st March 2024 financial statement. If that company ceases to be a small company because of the paid up capital or of turnover thresholds, then within 18 months of 31st March 2024, that means by 30th September 2025, they have to dematerialize their securities. In case a company is not a small company as on 31st March 2023, but becomes a small company as on March 31st, 2024, how to comply with the provisions? Technically, the securities have to get dematerialized. Thereafter, they may be rematerialized. That means, I hope that participants understood this particular thing. In case a company is not a small company as on 31st March 2023, because of that, before September 30th, 2024, they have to dematerialize their securities. Not necessarily as on September 30th, 2024, they have to dematerialize. Any time before that, they have to get dematerialize it. But suppose that company, it has become a small company during the financial year 23-24, then what will happen? Do I need to compulsorily continue to do that? That kind of restriction is not there in the rules. So according to me, they can get that shares rematerialized after that. So first of all, you have to comply with, because 31st March 2023 compliance is required, you have to get the shares dematerialized. And because of 31st March 2024 rules, you have that facility, you have the privilege to get the shares rematerialized also. Now, in case of such, private companies shall ensure that before making any offer for issue of securities, as I told you, rights or bonus, or even a buyback, entire holding of securities of its promoters, directors, KMPs has been dematerialized. Same provisions of unlisted public companies, they have been extended to private companies also. So every holder of securities of such private company who intends to transfer such securities on or after the date when the company is required to comply with this rule shall get such securities dematerialized before the transfer. That means the company shall not give effect to such transfer form or to such transfer application unless until the securities are in demat mode. Once the securities are in demat mode, we all know that the company need not do anything as far as the transfer is concerned, because it is the depository which transfers the shares, not the company as such. Now, every holder of securities of such private company who subscribes to any securities of the concerned private company whether in the private placement or bonus shares or right shares, on or after the date when the company is required to comply with this rule, they have to ensure that all the shares, the shareholding existing one should be in Demat mode before the subscription. That means if a private company declaring bonus shares, and suppose one security holder is continuing holding the physical shares, then you should not issue bonus shares to him. So in such case, what will happen is that rights issue or bonus issue may be kept in abeyance. These provisions, again, the way these are not applicable to a government company. So here also, these provisions of this rule shall not apply in case of a government company. And provisions of now the provisions of sub rule 4 to 10 of rule 9A. That means there are certain rules are there. That is rule number 4 to rule number 10 of which are applicable to a unlisted public company. Those rules are equally applicable to private companies also. Which are those rules? Let us quickly see that also. Dematerialization of securities shall be facilitated by the company, as I told you that, whether it is a listed public company or a private company, their responsibility is to get the securities in Demat form by approaching the depository, secure an ISIN number, and inform all security holders that this is the ISIN number. You may get your securities into Demat form. The company shall ensure that it makes timely payment to the depository and the share transfer agent, maintain security deposit of not less than 2 years fee at all times with the depository and share transfer agent, and it complies with the regulations or guidelines of circulars of SEBI and depositories. In fact, this when in the 2018 when I was addressing the several forums like this, I said that point of time also this provision is a very surprisingly that the rules are dictating the companies to about the making of timely payment to the depositories. Why the rules are not dictating the companies, I really fail to understand. It is between the depository and the company. And not only for the depository, even the share transfer agent. They say that the company shall ensure that it makes timely payment to the depository and the share transfer agent. And also they say maintain security deposit of not less than 2 years fees. This suppose the understanding with the depository or understanding with the transfer agent is only for the payment of the fees, not for the security deposit. But the rules say that they have to maintain a security deposit of not less than 2 years fees all times with the depository and the share transfer agent. And of course, it has to comply with the regulations and guidelines issued by SEBI and depositors. This is a very funny provision, but it is a law we have to comply with. In case of any default, such company cannot issue or buyback of any securities till the default is rectified. That means if you are defaulting in payment to your depository, if you are defaulting payment to your RNT agent, if you are defaulting in maintaining that security deposit, then in such case, you cannot issue any securities. You cannot also buy back any securities till the time the default is rectified. So the company shall file PAS 6 form duly certified by a practicing company secretary with the ROC within 60 days of conclusion of each half year. What is this form is nothing but the issued capital of the company and the capital as per the depository are the same. There is no difference is there. It should not happen that your capital is much more than that what is in the Demat mode because everything should be in Demat mode. In case of any differences are there in the issued capital and the dematerialized capital, the company shall bring it to the notice of the depository, and grievances, if any, of the security holders shall be filed before IEPF authority, and IEPF shall initiate action in consultation with SEBI. Now, if you see the applicability of the rules, again, the certain companies got exempted. Rule 9B, that is issue of shares by private companies. These is applicable to all private companies, but not applicable to small companies and government companies. Rule 9A extends similar exemption. That Rule 9A is applicable to unlisted public companies. Rule 9B applicable to private limited companies. They are not small companies. So Rule 9A extends the exemption to the following public companies, that is Nidhi companies, government companies, and a wholly owned subsidiary companies. So here what happened is, though under Rule 9A, wholly owned subsidiaries of a public company are exempt from dematerialization requirements. Similar exemption is not extended to private companies under Rule 9B. That means a subsidiary company of a wholly owned subsidiary of a private limited company, still they have to get their shares dematerialized. The exemption is not available to them. But in case of a public company, if that public company having a wholly owned subsidiary, it may be a private company. If it is a private company, obviously it will be a deemed public company, or it may be a public company. Then in such case, these rules are not applicable to them. So action points for a private company post notifying these rules is: issue all securities in demat form only, intimate to all security holders to dematerialize their existing share security holdings, facilitate the dematerialization of all existing securities. That means get an ISA, intimate to all the security holders and help them, and ensure that the entire holding of its promoters, directors, and KMPs are held in demat form only prior to making any offer for issuance or for prior to making any buyback of securities. Now, what are the action points for the security holders of a private company? They should get dematerialize the securities if you are a promoter, director, or KMP before the company issue any securities. That means, as a suppose if any company secretary is there or a CFO is there for that private company, they have to ensure before issuing any securities, they have to ensure that the promoter shares, securities, as well as the directors or of the KMPs are to be in demat form. So dematerialize the securities before subscription to any securities issued by private company. That means other than promoters, directors, KMPs, other shareholders, before making a part of that issue of securities by the private company, before subscription, they have to ensure that their shares are in demat mode. Otherwise, the company cannot issue the securities to you. Dematerialization of securities before proposing any transfer. So, because as I told you that transfer is possible only in demat mode. So, companies cannot entertain any physical transfer of shares. Dematerialize the securities before offering the securities in any buyback. That means if the company is proposing a buyback, unlike unlisted public companies, here you have to have that shares only in demat mode. Penal provisions, no specific penal provisions were provided for non-compliance with Rule 9B. So whenever the penal provisions are not provided as such, Section 450 of the Companies Act 2013 gets triggered, says that it is liable to a penalty of 10,000 rupees. That means if any kind of non-compliance of any section of Companies Act 2013 for which penal provisions are not provided with, 450 gets triggered, and that offense, that non-compliance is liable to a penalty of 10,000 rupees. And in case of a continuing contravention, that is continuing offense, with a further penalty of 1,000 rupees for each day after the first during which the contravention continues, subject to a maximum of rupees 2 lakhs in case of a company, and 50,000 rupees in case of any officer who is in default or any other person. Thank you very much for your patient listening. In case anyone has any questions, I may take them.
Um, so there are a couple of questions in the chat box. I will just read out. In case of a Section 8 company, where members of the company are only corporates, private and or a public company, the provisions of SBO won't be applicable per se. However, in such a case, whether Section 8 company is required to appoint a designated person, compliance officer, as per the notification of 27th October 2023. And a follow-up question is, further to that, if there is no company secretary or KMP in that particular Section 8 company, then whether all the directors are to be appointed as designated person.
See, number one, that whether it is a Section 8 company, no exemption has been given to that. So in case of Section 8 company also, I mean the SBO rules are equally applicable to that. So
Yes, sir.
whatever
But
the
in that case, sir, Section 8 company, if it is a company limited by guarantee and not having share capital, the question may not arise because it's only a guarantee company, it doesn't have shares. So beneficial ownership of shares should not be applicable per se.
voting rights might be there,
Yeah, voting rights are
distributable
there.
voting rights are there. So that's why what it said is, if you see the significant beneficial owner
Yeah,
definition,
yeah, it
it
is
is
voting,
10% of the capital or
or
10% of the
voting.
voting rights or 10% of the dividend or suppose none of the things are there. Somebody might be exercising significant influence or control. Suppose a person who is not holding a single share, not having a single voting right, not entitled to a single rupee as dividend, but still, if he is exercising control or significant benefit, significant influence, he will be the SBO. So
Okay.
even in case of Section 8 companies, where there may not be any capital, there may be a guarantee company or a security company, but still, SBO rules, you have to see that is there any person having a voting right, or suppose voting rights are not there, but that person, anybody exercising a significant influence or control, he will be the SBO. So you cannot just say that Section 8 companies SBO rules are not applicable. It is not so. Yeah.
Okay, sir.
You say
There's
that if
one
there
more
is no
question.
CS or KMP, does all the directors are to be appointed as designated persons? What do you mean by designated person?
It's a designated compliance officer for SBO. You are supposed to appoint mandatory by every company.
See, to the best of my knowledge, I don't think that SBO rules are asking you to appoint any person as designated person. It is only the compliance officer who has to ensure the compliances. I don't think that SBO rules anywhere asking you to appoint a designated person. Suppose if the company secretary is, pardon, yeah.
It's
Suppose if the
recently introduced on 27th of October. They have said that you are supposed to appoint.
okay, suppose I may be, I mean, okay, I might have slipped that thing. If it is there, suppose a designated person who has to ensure the compliances, then you have to appoint a designated person. Suppose if the designated person is not appointed, then obviously what happens if the directors have authorized a person before appointment of a designated person, if the directors authorized somebody, that authorized person will be held responsible. If it is not so, all the directors have to be held responsible. That is clear.
Okay, sir.
Yeah.
Then, as far as my understanding goes, it says you have to appoint CS or KMP. If they are not there, then all the directors have to
Yeah,
be
yeah, correct.
designated, and you have to
Correct,
pass a
correct.
resolution. And at the I think in the annual return they will modify and they will say that you have to mention who is the compliance officer for SPO purposes.
See, for example, if you are the company is not having a compliance officer, the company is not having a company secretary. Sometimes it may not be required, sometimes it is required, but they have not appointed. In such case, what happened is sometimes the board may authorize one of the directors
Correct.
or one of the officers of the company.
Yeah.
They might have entrusted him with that responsibility of compliances. So that
Correct.
officer in default provisions gets triggered in such case. And in such case, that all directors will not be held responsible. The officer in default will be held responsible for such
Correct.
non-compliances.
Correct.
Suppose if the officer on default is not what's called appointed as such, and the directors are simply having a layback attitude, obviously in such case they will be held responsible. All of the directors as such.
Correct.
But where you have a managing director, suppose,
Yeah.
then in such case there is no KMP appointed. That means, of course, apart from that managing director, no CFO is there, no CS is there. Even if CFO is not there, also somebody CFO is there also. It is the managing director who is expected to ensure the compliances, not the CFO. So in
Correct.
such case, managing director may be held responsible for that, for the
Correct.
compliances.
Okay, so we move ahead with the next one. What if the company is incorporated pre-notification and the shares are required to be issued in Demat form or physical form?
See, the way the things are there, in fact, okay, suppose for the if a private company is incorporated, The wording is that they cannot issue securities in what's called, they have to issue securities in demat form only. So what happened?
Yeah.
The moment the company got incorporated,
Hmm.
you don't need to, you have to allot the shares. You don't need to issue
Yeah.
the certificate. I think that 60 days time is there for you to issue the certificates.
Yeah.
So according
Yeah.
to me, you have to get the securities admitted in the depository and you have to issue the shares only in demat mode. Number one. Number two, in case of incorporation of companies, there is no question of issue of shares.
Correct.
There is no question of even allotment of shares also. You don't need to allot the
Correct.
shares. These are
Correct.
subscribed shares. So
Correct.
I can take a call. I can take a call that you can issue physical certificates because you are not issuing the securities there. So in case there is a time being taken to get the securities admitted in the depository, by all means, because in the meantime, the investors want some kind of a proof. You can issue a share certificate, but subsequently it is advisable to get them dematerialized.
Correct.
Any
So,
issue thereafter, you cannot issue it in physical mode. Okay?
so barely a newly incorporated company may find it difficult even to get their securities admitted
Correct.
to this thing
Correct.
because
So that is the
you
reason.
don't
That
have
is the
anything
reason
in the
for the
company at that point of time.
that is the reason for the benefit of the participants. I am saying that with due regard, some professionals are not knowing that. They think that even when the company got incorporated, the shares are to be allotted to the subscribers to the memorandum. No share
Correct.
allotment is required. You have to simply, the first board meeting, the directors have to note that these are all the subscribers to the memorandum who have given their intention to subscribe for that many number of shares.
Okay.
Okay. So it
Yeah.
doesn't amount to issue of securities. No form 2 need to,
No,
I
no,
mean,
no,
that
no, no.
form, that pass 3 need to be
No,
filed. Earlier form
no.
2, now pass 3 need to be filed also.
Correct.
Okay. Yeah.
So the next question is, a company filed Form Ben2 timely. Later, the company went on two different occurrences of buybacks. This resulted in a change in the holdings of SBO, but they were still SBOs. Should we file Ben 1 and Ben 2 for every change, or we can file only once for the final change?
The technical, this
Because
is
there
what
are
I
two
said that for
buybacks.
every change, the word used there for any change. This is what exactly I was mentioning that suppose if I am an SPO, I am holding, say, for example, on 100,000 shares of a company. I sold one share to somebody. Now my shareholding as SBO changed. Doesn't amount to a change. That clarity is not there. Change in the SBO means I have become an SBO and I have ceased to be an SBO. Is that the change? Or any change in the holding of my change in the sharing of the SBO? That is not clear. But the way the rules are notified and all, my interpretation, and to a large extent, this is the interpretation of the fraternity also, is that any kind of change in the shareholding of that SBO, he has to file LLP Ben 1 in case of LLP or Ben 1 in case of a corporate, and the company in turn has to file Ben 2 or LLP Ben 2, whatever the case may be.
Okay, sir. And the
That is a
last
gray area which
question.
is there. Yeah.
Yeah, that's true. Can you, sir, as I understand, you are a licensing or advisor, I won't say, you are licensing with even MCA or the regulator also. So if you can just tell them to have a bit clarity on that, would be advisable if they come out
See,
with some clarity.
see, Preeti, as I have mentioned to you, this we have brought to the notice of MCA. In fact, let me say in the four walls of this, in fact, that point of time, I have been asked a question that what do you mean according to you is should be a percentage or what exactly it is? I said that look, like takeover regulations, every change of 2% shareholding is to be intimated, or 5% change of the change in the shareholding is to be intimated. So I said that like that, why can't you bring number one? Number two, I said that according to me, the objective of SBO is to remove the opaqueness. Once the opaqueness is removed, it doesn't matter what is his shareholding going to be. Okay. So if I am becoming an SBO or I'm ceased to be an SBO, that should be considered as a change. This we have already submitted, but somehow till date it has not been done. But maybe we may approach the ministry once again because According to me, another amendment bill might be in the offing post the elections because the what's called the committee which has been set up, they have been given an extension of 1 more year. So this committee is going to already certain changes have been made to the I mean proposed to the Companies Act 2030. Most probably, maybe when the new government sets in, that I mean it may come some amendment bill. Maybe that point of time they may address the issues like this. In fact, today only I have seen that again, was ministry is asking for some kind of what's called the recommendations or wherever you have difficulties and all. Maybe we may approach them once again with that. That's what I can
So
say.
let's hope for the best in 2024. We have more clarity, less of
Yeah, yeah,
ambiguity.
absolutely, absolutely.
So the last question, uh, the SBO forms for LLP are not yet visible on MCA portal. It's sort of information, or if you have any information about that, you can clarify.
See, as far as the forms are concerned, I don't have any kind of knowledge or command on that because when I was in service, most of the time my colleagues used to file the forms. I have been told that MCA version 3, lot of difficulties are there in filing the forms and all.
It's
Since
true.
I am for the last, I think almost 20 years, I have not filed a single form. I am completely illiterate as far as the forms are concerned. So I express my inability as far as the this thing is concerned. But there might be some kind of a difficulties which we have to live with. That much only I can say because several colleagues of mine they always say that a lot of problems are there in with the MCA version 3. I think
Which is true.
to some extent they have been settled and still the problem is there. The institutes are also struggling with the MCA and MCA officials. If I'm not see, sometimes when you go and meet them and interact with them, they are also suffering. Not only we, because they are the implementers. They are the people who have to get the act implemented through us. So it is their responsibility also to understand if we are facing any difficulties. And let me say, with all modesty, Ministry of Corporate Affairs, my interaction with them earlier, whenever I got the opportunity, they do hear you patiently, but they cannot bring the changes in the act just like that because that is a very long drawn process. But wherever the rules amendments are concerned, the moment there is a difficulty, because I know that Section 135 corporate social responsibility, when the rules were notified, when the ministry came with the FAQs, because they say that, look, we cannot make the changes to the rules just like that, but we will come with FAQs and we'll give you some kind of a clarity. That time also, both institutes, chartered accountants as well as company secretaries, have approached the ministry, and the ministry said, okay, three of you depute three people from each side. We will listen to them, and then we will come with the FAQs. So again, I was a privileged soul from the ICSI side, and we have given them a lot of changes in that FAQs. And ministry was kind enough to give those FAQs authenticated. Because of that, more or less, it is a rule now. And a lot of benefit has been given to the fraternity. Otherwise, it would have been difficult to implement CSR rules. Okay.
So we just need little more acceptability from the ministry that there is a problem. At times we feel that they are not that in an acceptable mode, that yeah, there is a difficulty in implementation or filing. We are facing difficulty. So if they are able to accept it open-heartedly, it is more advisable. It
Anyway,
makes our
that
life
I'm not,
little better.
I'm not a representative of any chamber or any government as such. But wherever, well, I mean, I can do something, from the ICSI side or ICAI side. If I get an opportunity, I will certainly do it. But at the same point of time, BCAS can also do. I know BCAS for the last almost 25, 30 years. They're doing a wonderful job. I am an ardent fan of that journal, especially, and the editorial column, Namaskar, all these things I'm an ardent fan. And BCAS also can approach with the kind of difficulties, whatever they have.
So BCS has already done that, but still we are not probably able to have significant influence over them on this part.
Correct, correct.
So let's
Might
hope
be
if
because
through you,
but
if we are able to have.
one thing is definitely there. Whatever the suggestions they go, it is not like that they are putting in the dustbin as such. But as and when they bring any kind of changes, that point of time they do consider all these things. And that's what my experience with MCA is concerned.
Thank you so much, sir. I can say that today we all are the beneficiaries of the mastery knowledge sharing and rich vast and varied experience of yours with respect to SBO as well as Demat of securities. Compulsory Demat by private companies may be probably to reduce the frauds or litigations relating to the securities. Because as I understand from one of the regulators few years back, said that majority, substantial, it is more than 50% of the litigations which are there are relating to closely held public companies or private companies. So it may be with an intent to reduce such frauds and litigations. You all will agree that
propensity to litigation, I can say. Propensity to
correct.
litigation.
Correct. Sir, you've explained such complex topics, subjects in a very lucid manner. I, C.A. Preeti Oza, for on behalf of the Corporate and Commercial Laws Committee of BCAS, and also on behalf of all the participant beneficiaries of today's study circle meeting, extend a very well-deserved hearty vote of thanks. And we also thank from BCS all the participants as well.